Welcome. My name is John Pack. I'm with the Carson City Republican Party. I'm the vice chair, and this is my colleague Lucia Maloney helping. And we're just interviewing candidates as they're running for office to get their ideas and thoughts and concerns about the office that they're running for and what their philosophies are. So the first question we've been asking everybody is, give us a kind of a brief walkthrough of your legal career and what led you to run for this office.
Okay, so for my legal career, let's see. Start with where I went to school, went to Florida Coastal in Jacksonville, Florida. I got a scholarship, and when you're looking at paying for grad school, it's not a cheap thing, so I went there. In my time there, for one of my semesters, I actually got to come back here and clerk at the Supreme Court. So that was fantastic. So I spent a semester of my law school time here in Carson City. After that, I was a clerk in the 8th Judicial District Court for Judge Filani. And then I went to work here in Carson City for the Attorney General's office. So I started there doing civil rights litigation and medical malpractice litigation. So after a little bit of time there, I joined the Carson City District Attorney's office in 2015. And I've been prosecuting crimes here in Carson City since that date. So in the office, I moved from deputy to supervising deputy to chief, and then ultimately I was appointed to district attorney.
And now, district attorney is obviously an office that's open, but you chose to run
Yes.
for justice of the peace, right?
Yes, I did.
Okay, so what led you to go that direction rather than kind of stay in your current lane?
Okay, so I don't know how much time you guys have spent in the Justice Court. I absolutely love the Justice Court, so that's probably good. So nearly every case that comes into the Carson City court system starts in the Justice Court, whether it's a misdemeanor, whether it's a felony, your protective orders are there, small claims are there, it becomes the court of the people. So for a prosecutor's time, the majority of time we actually spend in the Justice Court. Because even on those bigger felony cases, whether it's a murder, a sexual assault, or anything like that, they start with a preliminary hearing, which is essentially, you could call it a mini trial with a lower burden, to show the justice of peace that there's sufficient evidence to have a trial. And then every, obviously, misdemeanor crime, all of those things are there. But the impact you can have in the Justice Court is huge, especially when it comes to community safety. They decide bail. Who's out when, who's not out. They're looking at the misdemeanor sentences. So if you were to take rough averages, 2 out of 3 crimes that come in are going to be dealt with at that misdemeanor level anyway. And they're what we would call a quality of life crime. And so you get a lot of people that are first time into the judicial system. Maybe it's a DUI, maybe it's a theft. And there's the opportunity there to not only provide accountability, but also a path for that person to change their life. Now, if they don't change their life, that's on them. Then they're looking at incarceration and probably something worse. But the amount of times that I've seen people make those changes is huge. I recall prosecuting, it was a felony DUI, so by then we had gone through the Justice Court into the District Court. The jury foreman I had was a prior misdemeanor defendant. And so they'd gone through it, and 15 years, they didn't have any further interaction, completely changed their life. So for me, that ability to work with people day to day and make my community a better place is probably the biggest reason for me to run for justice and peace, because it's something I'll be able to do and help my community be better every day.
What do you see as the single most important qualification needed for the role, and how do you demonstrate that qualification?
Single most important qualification. That's harder. I was going to narrow it to 2.
That's okay.
Okay, I would call it a blend of knowledge and experience. So the Justice Court, the way it works, it happens fast. So you have a high volume of cases that have to be dealt with expeditiously, otherwise you're just denying justice. If it's delayed too long, it's denied for a community. But the things that happen have to happen right away. Take a search warrant. It's going to happen in the middle of the night. You either know the law or you don't. And that's where that education is important, because if you don't know the law, you may allow someone to violate someone else's constitutional rights. That's wholly improper. You have to know. It's not like you get a chance to just, let me research this. I know that officers want to get into this house or this car or do whatever. You get it right or you don't. I've done hundreds of warrants. And so that kind of experience is fantastic. I've never had a warrant overturned. So that's also really good. So, and the majority of those warrants were done in the middle of the night, because that's when the phone calls happen. So that part's important, but also having a firm understanding of the rules of evidence. So you're going to get 2 types of litigants in your courtroom. You're going to get persons who are represented by counsel, and then you're going to get the unrepresented. There's small claims, and sometimes there's just minor cases where a person doesn't hire an attorney. If you don't know the rules, it can often allow one side to get over on another unfairly. And so you either know it when you're there on the bench or you don't. And that type of fairness is what this community is going to count on. Otherwise, it's going to disadvantage the people of Carson City if there's someone that doesn't either have the experience or the knowledge to make those proper decisions, because the time to do it is right there.
On that note, you mentioned fairness. What other ways do you ensure impartiality and fairness, like in your rulings and the whole process?
So one of the important things, we'll start with impartiality. Impartiality is necessary. I mean, if there's some type of conflict of interest or anything like that, that should be disclosed immediately. There are conflicts that are waivable type of conflicts, and there are others that just simply aren't. You can't sit in judgment of a family member. That doesn't work, right? I think the statute takes it to the third degree of consanguinity, which is the relationship that's there. So those kind are out. There's other times, Carson City's small. You're going to know people. I have appeared before judges and they're like, I know this guy. That was my son's baseball coach 15 years ago. You have stuff like that. Those are automatic conflicts that are disclosed right away. The parties can either waive them, and it's subject to the party who would have that conflict to make sure that they're before a fair judge. So ensuring that all that's out in the open. The other thing is going to be just general fairness. One of the most important things about fairness is hearing people out. I think it goes a long way in people's belief and understanding of the functionality of our justice system that they did have a fair shake when they were in court, if they're heard. And that, to me, is absolutely essential. I mean, it's important for a judge to ensure that proceedings are moving along. You don't want to see wasted time. Everyone there usually is taken off of work to be there, and so you don't want to see their time wasted, but also ensuring that all of that relevant information comes out so that the judge can make a proper decision based upon all the facts.
How do you describe a situation where you faced a potential conflict of interest, and how did you address it?
Okay. They've come up. I mean, so I've had neighbors prosecuted, and with those, now with my position, if something like that comes, well, let me take it back. So before I was the district attorney, we could pass it off to someone else in the office, right? It makes it easier. Like, oh, you realize, like, can't do this one. I know them. Even if you don't know them well, generally the position we've taken is to avoid the appearance, even the appearance of impropriety. We're going to pass that off, make sure that person's isolated from it. Now in my role as district attorney, because my name is on every pleading that goes out there, one of the simple things that I do, if it's someone that I know like that, then usually I conflict it to another agency, being either the Douglas County District Attorney's Office, the Attorney General's Office, the Washoe County District Attorney's Office. Because even if there wasn't what we would call a true statutory conflict where it's defined in our rules of ethics, the last thing I would want is the public to even have the view that someone was given a benefit or that we came down harder on them because of whatever perceived relationship is out there. And that's come up. I mean, we've had that happen with a few cases. There's a current case right now that we have conflicted for that very reason. Not that I would call it the biggest or the truest of conflict under the rules of ethics, but I didn't even want it to be the appearance of that.
Fair enough. What steps do you take to maintain public trust and confidence in the judiciary?
Public trust and confidence. Probably reiterate a little bit of what I said, avoiding those conflicts that we have and making sure that they go to the proper agencies. Listening to people. To me, that's one of the most important things, whether it's in a criminal context or in a civil context. I mean, I get emails on the regular, I get calls on the regular, some of which have basis and they've called the right people. Sometimes they didn't even call the right county. Instead of, one of the standing things I changed in our office and that culture is, even if people have called us and they're found the wrong agency, let's hear them out and help them get to the right place. The last thing I want is for any member of our public, this county or another county, to be stuck in this game of telephone where they feel like they're just passed on to somebody else because nobody wants to give them the time of day. Because like I said, if people feel listened to, it gains trust in the system.
With sentencing questions, what are your philosophies and principles regarding sentencing in general?
All right. So it varies on the type of crime. So I guess I would break that question down into our, we'll call them our petty crimes, our minor crimes, and our more serious crimes. I'll start with the serious crimes. If we're talking crimes of murder, robbery with deadly weapon, sexual assault, child pornography, those types of crimes, it comes with incarceration. That's just what it is. It's a punishment thing, and it's a protection of the public. The last thing I want to see is someone placed in a position where they could reharm the public. And so we prosecute those cases very vigorously. So sentencing, as that would be, I guess in the justice court, they wouldn't, justice of the peace don't sentence on those kinds of crimes, but they certainly do set bail conditions for those. So paramount for me on the bail conditions would be community protection and victim protection. When it comes to the minor offenses for most people is their first interaction with the criminal justice system. So I've always taken kind of a sliding scale approach to that. There's petty theft. That's probably the easiest one. You came in, you stole from one of our establishments. The officers either cited you or arrested you, but most likely they cited you. So those are often met with community service and restitution. You got to repay what you stole. You got to give back to the community. You do it again, we're looking at some jail time. You do it again, we're looking at more jail time. And we get to this point where we almost just start doubling the sentence. So a misdemeanor can be punished by up to 180 days in jail. But sometimes we had a guy come in, he was stealing from Food Max. He's doing 1.5 years now because he just didn't stop. So if you don't want to stop, we'll make sure you stop.
Balancing the goals of justice, deterrence, and rehabilitation. How do you do that when you're not necessarily, as you said, you're not necessarily sentencing folks, but from the bench you're going to have those kind of balancing acts.
And I would sentence on misdemeanors. So anything that's a misdemeanor, and there's a lot of stuff that, like I said, the majority of cases do resolve at that misdemeanor level. Mm-hmm. So there's a number of things to take into consideration. One, we'll start with a fiscal look at it. It costs more to incarcerate someone than offer rehabilitation. Dollar for dollar, that's generally what it is. Mm-hmm. So if an individual can be in the community and make the changes that they need, after we've addressed public safety and those types of things, mm-hmm. It's going to save the community money and hopefully put them in a position to not come back. So if it's an addiction issue, we have a specific specialty drug court at our misdemeanor level, where all the participants are in there on misdemeanor crimes. So mm-hmm. if it rises to the level where they need substance abuse help and they're not doing it on their own, they may end up in that drug court. We have a number of people in our mental health court that are in the same way. They came in from misdemeanors. Either they weren't managing their medications or they decided to combine their medications with meth. Doesn't play well, as you can probably guess. And so they need a different level of assistance. So you have, I guess, that drug side. If we can provide them the treatment, or I should say, it's not us providing them the treatment. We can send them to the location for treatment. They're going to pay for that treatment. They can either get on board or not. If they don't, in my mind, they're looking at incarceration. If they do it, that's great, because if they're not coming back, it's better for their life and it's better for our community's life. And like I said, then on the other types of crimes that aren't necessarily substance abuse driven, where you have some people who are just exhibiting criminogenic factors or making consistent bad choices, then the decision really becomes for them either I'm going to give you the choice. If you're going to take the probation route, you're going to follow and do what you got to do, or if you're going to come back on violations, you're just going to serve your time.
And so those same lines, and you briefly touched on maybe some of it, but what factors do you weigh into the decision on whether or not this person is getting jail time or a rehabilitation time? Is it just first time offense? Or
no, there's a little bit more there. So we're going to look at nature and seriousness of the offense, mm-hmm. And then we're going to also look at their history. I'll look at their performance on past probation. Do they have past violations and those types of things if they do have a history? And the type of history they have matters. So you could have someone who has, let's say it's a number of possession of drug paraphernalia crimes. Okay, those are misdemeanors. It's different. Let's say they've got 4 of those. I feel very different about that than someone who's got a domestic battery and a harassment. So I've got a guy with 4 priors over here versus 1, 2, but they're presenting completely different community safety risks. So that's why I looked at the nature and seriousness of that offense first, because if it's aggravated enough, I mean, if it's domestic battery and they have beat that person up terribly, they can just serve time, mm-hmm. right? I mean, that's kind of one of those things. So I'll start with that, then I'm going to go to the history, I'm going to go to their performance on past history, we're going to look at ties to this community, we're going to look at work history, and balance all those in to see if there is a way that this works forward on a probation status, and if it doesn't, then it doesn't. Then it's an incarceration.
Okay.
Talking about immigration, how do you ensure that all individuals, regardless of immigration status, receive fair treatment in your courtroom?
Okay, so for me, this is a simple one. That's one of the ideals we've espoused in the district attorney's office. Immigration status doesn't play in. You committed the crime, you committed. No one gets a benefit because of their immigration status or an extra punishment because of their immigration status, and I would treat it the same way as a judge. So if there are immigration consequences associated with a crime that an individual is found guilty of, that is what they are. That does not mean that we're going to lessen the state standard, we're not going to lessen the punishment, we're going to look at it the exact same way, exclusive of the immigration status.
And what is your approach to cases involving illegal immigration specifically? How do you address the legal challenges that they might present?
So the legal challenges in the Justice Court are somewhat simple, in the sense that if an individual is presented in the Justice Court, let's say they have an immigration hold, well, they're not going to make bail at that point because they have a hold. If they were to be released to bail, they're automatically released to that hold, and ICE would come pick them up and they enter deportation proceedings. So generally those people don't ever post a bail, even if it is at a smaller level, because they know they're going to be immediately picked up by ICE. So from the Justice Court's position, that usually addresses that, but we're going to make bail, like I said, the determination the same way, exclusive of that detention status. Bail is based upon community safety factors, and they're outlined in NRS and within case law, and immigration status is not one of those considerations. So the way it works in Carson, like I said, if they're released to bail, Sheriff's Office notifies ICE, and then they're going to be picked up.
On that bail topic, cashless bail, other types of, how do you go about it? There's, of course, in the news, the different jurisdictions that have cashless bail and that sort of thing, and that's a big, I think, topic in communities and public safety.
Mm-hmm.
And what is your philosophy on all things concerning bail, when it should be used, how it should be used, should there be cashless bail, or what alternatives are good in place of cash bail, for example?
So no matter we don't have a cashless bail system, we still have a cash-based bail system. Actually, I think it functions fairly well. Cashless bail often allows persons to continually be arrested and evade detention, mm-hmm. which can present consistent community safety issues. With the current system that we have, it allows the court to basically consider the history along with the offense that they have. Mm-hmm. And so the bigger the history, or the bigger the offense, the bigger the bail. Mm-hmm. Because it's all about likeliness to reoffend and reharm the community, and it's also about, are they going to come back to court? Mm-hmm. The bigger the risk, the more desire you have not to come back mm-hmm. to court. Right. So when it comes to those things, I mean, having worked now for the past 10, 11 years within the bail system and within the case law that we have, it's spelled out pretty well on when bail is appropriate, how it's appropriate. We have very few instances when no bail is appropriate, generally in the case of murder or things like that. They do come up. We even have separate bails that can come on to an offense, either based on probation violations. They have a separate bail that attaches, and bail can be applied per offense and not even just per arrest, so it can stack up that way to ensure compliance. But to me, it's about keeping the community and the victims safe and ensuring they come back to court.
What is your judicial perspective on the Second Amendment and gun rights within if
everyone has the right to bear arms. Second Amendment's pretty clear. That's the way I see it. I don't know what else I could say on that one.
Okay, well,
people have a constitutional right to bear arms. Any restrictions on the Constitution, I mean, it's a strict scrutiny test that's going to be applied. And so, as far as the justice of the peace, I mean, the laws on the books, both federally and across the state, are the laws on the books. That's what they are. Any of those laws that otherwise fail to challenge is decided by our Supreme Court, the United States Supreme Court.
And have you been involved with any cases that have involved violation of the Second Amendment or gun rights in general?
Sure.
And how have you handled them, or how would they?
So I want to make sure I'm understanding your question correctly. I've been involved in many cases that involve firearms and may result in persons' loss of right to bear firearms. Mm-hmm. So obviously, if you become convicted of a felony within the state of Nevada, you can lose your right to bear arms. Mm-hmm. A subsequent offense to that is convicted person in possession of a firearm. We have prosecuted those offenses, and I can say pretty much almost every time that we've come across them, we're finding them in the commission of another crime, which is how they come to. It's this rare thing that people think that officers randomly contacted someone and they had a gun and that was the only basis for arrest or why they were there. So nearly every one of those has been for that, or it's been for conviction for domestic battery, which also has the same requirement.
And I've been asking folks about differences between constitutional carry and CCW and the philosophies about what they kind of support and what they don't support, and what if any way you would like our system to change, or if you think it's really good the way it is, or anything along those lines.
So we have the ability to open carry. The ability to obtain a concealed carry is not necessarily that difficult within Carson City. It's obviously very different if we were to live somewhere like New York. Their system is flawed as can be. But for us, I mean, providing essentially a concealed carry class and having the determination by the sheriff's office that there's no items in an individual's criminal history that otherwise prevents them from carrying is generally the standard that all those requests that go through. And so as far as its functioning within Nevada law, it's pretty rare that we have I can't even think of a concealed carry case where they weren't otherwise using the gun illegally on the ones that I've prosecuted. So again, it hasn't been ones where it's someone who just happened to have a gun that I can recall off the top of my head. It was usually illegal use. I'm trying to think. We had one that resulted in the death of an individual here in Carson City that we prosecuted, and they were illegally carrying and concealed carrying. They were kind of doing both at the time. So, yeah.
And so just one other question on that. A specific example: guys walking down Highway 50 with an AR-15 on his back, not threatening anybody, just walking down openly, seeing everybody, business, frightened, or whatever. Somebody calls it in, sheriff's office. Sheriff goes and does whatever they do, but this guy comes before you on whatever charge the sheriff has brought you. What is your point of view on that kind of
So to me, I'm going to look at the charge. The charge is either legal or it's not. To me, it's kind of that simple. If it's otherwise an open carry and there's nothing there, then there's no basis for the charge. So one of the things that a justice of the peace specifically does, upon any arrest, usually within 24 hours, they're going to review the probable cause sheet. They're required to under Nevada law and make a determination that there's sufficient probable cause set forth within that declaration by the officer for there to be a charge. If there's not, it's dismissed and it's done. They don't. That's actually even before the person even gets to the judge, because the goal is that it's done within 24 hours. So if there's no basis for the charge, there's not.
What is your vision for Carson City's district court over the next 5 years?
District court or justice court?
Justice court.
Okay. To me, it needs to be a place where people feel that they are receiving justice and is taking care of their community. And there's a few ways to me that this happens. One of them is the efficiency of the system. So one of the things I did as DA that I think kind of carries over is we reduce the amount of time it takes to move a case through the system. And this matters for a few reasons. For the victim, it makes a big difference. Cases often can get continued, they can take time. That is hard on a victim. That's really hard on a victim because, like I said, the further that justice feels delayed, the further you feel like it's just not going to happen or that it's less than. And the other thing also is for the defendant. We have a lot of people, they're either made bail of their own accord, and these aren't probably the biggest offenses in the world, they're back to work, those kinds of things, but maybe they need some type of programming or something to help them be more successful in life. The longer it takes to get to that point, the more time we're just waiting, and they don't necessarily have the tools that they should have had because they should have already enrolled in counseling, that we're risking another violation. So the faster it moves through the system is better for everybody, and it's better for the taxpayer. Because if it's moving through the system faster, we're having less hearings. Less overall hearings reduces the congestion of the court, which lets other cases move along a little quicker, but it just reduces the taxpayer burden in general.
And you were talking about victims, so how do you balance victims' rights with
The rights of the accused.
Yeah.
Okay, so both of them have constitutional rights. So we have everyone's aware of, we've got our Fourth Amendment rights, we've got our Sixth Amendment rights, we've got all those that belong to the accused. So in Nevada, under Article 1, Section 8A, you have Marcy's Law, which provided constitutional rights to the victim. So those have to balance out.
Mhm.
And your question being, how do you balance those? That gets tricky. I won't lie to you, because an individual, let's say an individual has a right to have their preliminary hearing on a felony case within 15 days. So they have that right. If they invoke that right, it's great. But what if they don't want it then? They have the right to waive that. But the victim also has the right to have this case move through the system in a proper manner. So the thing is, at some point, the judge has to tell the defense, like, you've had enough time to be prepared. It's time. The state's ready to put their case on, let them put their case on. And conversely, I mean, if the defense needs all of their discovery, which they're entitled to have, and we kind of have an open file discovery process in the DA's office now, once we get it, we send it. There's no need to hide the ball, because if it gets to them faster, they can review it faster, which moves it through the system. Victims also have a right to make statement regarding bail. They have a right to make statement at sentencing. The defendant has the same rights to make statements then too, so both people get to be heard, but there are certain orders in which that happens. So a victim is heard last at sentencing. It's one of those important things. They do get that final word. So knowing those rules ensures the protection of everybody's rights, because they're not always spelled out so clearly within the law. There's just extra cases here and there.
Can I go back to the previous question? You talked about shortening timelines. And,
Yes.
And what specifically can be done to do that, and what resources would you need to make that happen?
So I can tell you what we did. We're down to about 4.5 months on average no, take that back. I think it's about 2 months. It's about 4.5 months on a felony, about 2 months on a misdemeanor. That's huge. If you were to go to any of our surrounding jurisdictions, especially Washoe and Clark, you are not looking at resolutions that fast. So what we did in the district attorney's office, to me, the district attorney's office was the first step in this. So we changed completely the way we operated. So we adopted a paperless case management system. That changed a lot. We save about, I think of our administrative staff hours, probably 6 to 8 hours per person per week was saved when we changed our system. That was a whole headache to do, but it was worth it. So what it allowed us to do was process our discovery faster. So it's sent to defense electronically. We also worked out with the sheriff's department to get it to us faster. So one of the things that Sheriff Furlong has been big about is deputies finishing their reports on time and accurately the first time. So he and I have an ongoing dialogue. If there's an issue or things look like they're starting to slide or anything like that, we call, he addresses his people, I'll address my people. So most of the time now, we get our stuff from the sheriff's department, almost the entirety of discovery on a misdemeanor case, usually within 72 hours, which is absolutely incredible. When I started, it was 5 to 6 days. So we've cut it in half, which is huge. So as soon as we get it, within 24 hours, it's to the defense, which means by then they've already had their attorney appointed, if it was appointed, or they've already retained it. They're already reviewing it prior to that first status check. So if they came in on a minor felony that may resolve as a misdemeanor, they already have a status check schedule on that, usually within 10 days of arrest. So we're resolving a high number of cases at that 10-day mark, which is fantastic. It gets them moving, and a lot of these are generally your drug cases. They can resolve a little faster. When we have the victim stuff in there, we're also working to make sure we get all the information from the victim, if there's restitution, anything like that, into our discovery process as soon as possible. And as I've told our prosecutors, you gotta be ready to go. Put your case on. And so from the justice of the peace side, it's holding both parties accountable. Holding your defense attorneys accountable, like, you need to talk to your client. You need to have talked to him before this hearing so that you can be ready to go and know, hey, we're either scheduling this case for a trial or it's going to resolve. What are we doing? And not letting things just kind of linger. If they need a little bit more time, it's keeping those extra bits of time to the minimum. Instead of continuing something out 8 weeks, it's like, no, we'll be back here in 3 to 4 weeks. That creates, when we first started this process, it creates a bubble or a mound in the amount of cases you have. But what I did find is once you work through that, it reduces the overall amount so that you're then moving forward. You just have to clear that backlog and you can get there. So for a little bit of pain, a lot of benefit can go. So for me, it's a judge is holding people more accountable to get it through. Sorry for the long-winded answer.
Fantastic. No, that's helpful. Why should Carson City Republicans in particular, here in the Republican office, support your candidacy? And if you'd like to tell us what distinguishes your judicial philosophy from your opponents.
So I think the best thing that they could know is, one, that they're always going to be heard and get a fair shake in their courtroom. To me, those are incredibly important things, but they're also going to have the confidence that the person hearing their case has the knowledge and experience to properly adjudicate it. And that makes a big difference. Knowing the rules of evidence is absolutely essential. And so some of the differences between me and my opponent are simply that. It's knowledge and experience. This is something I have been working in the justice court, like I said, for the past 11 years. I mean, I've thousands of hours of logged court time addressing the day-to-day and, the one-offs, the things that nothing quite prepares you for. And so I've had a lot of those types of things. So they would get the knowledge, they would get the experience, and they would also get a level demeanor. Good decision making, not allowing oneself to be riled. A lot of times people come into court, it's usually not their best day. Makes sense. Either they were arrested, again, not their best day, or they were a victim of a crime. Obviously, it wasn't their best day. Emotions run raw. And I think it's important for a judge to be able to see that, see people as people, that they're coming in, that maybe they're not presenting on how they should be. And unless you've seen that, like I have over the course of 10 years, it's easy to miss. It's easy to see people's outbursts or other things. They can get under people's skin. I've seen it. I've seen judges lose it. I've seen attorneys lose it. General members of the public, right? All of the above. But I'm one of those people who's been able to maintain that level head, to be able to see through some of that extra drama and to be able to see what really happened, and also to see through some of the BS. You would be surprised how much BS is often thrown out in court by people distorting or changing things and showing what actually happened versus what didn't happen, and then separating simply people's perspective, which can be different, doesn't necessarily mean that people are lying. Then you have some people who just come in and straight lie, or they play it up, or they make it out to be what it's not. And so it takes a lot of experience to see through that so that you can provide good judgment to people.
And is there any one thing that would come to mind that you wished people understood better about judicial discretion or about the justice of the peace job, or what they do?
I think I would love it if people really understood how much it affects their daily life. So if you were to look at judges in other jurisdictions who rule in very different ways, the quality of life that they have is affected by it. They may not see it. Nobody wants to go to Walmart and see an entire store locked up. Mm-hmm. Remember a few years ago, kids and I were going to Disneyland. Mm-hmm. We had stopped, I think we were an hour outside of Anaheim. We needed to go to a Walmart. 3/4 of the store was locked up. Mm. And it's locked up for a few reasons. I mean, if you have state not bringing charges, you have judges not sentencing, you have an absence of accountability. All those came from everyday quality of life crimes. The person who sits in our justice court roles has a big hand in how safe our community feels and how safe it actually is. Mm-hmm. I mean, I don't mind sending my son on his bicycle to go ride to his friend's house. I know what's in this town. I guess it's cursing the benefit of being DA. I know the really bad that goes on in life happens everywhere. I know also that compared to our surrounding counties, we're an incredibly safe place to live. Mm-hmm. And as a justice of the peace, I want to use all my experience to ensure that my community stays that way.
And if I don't know how much justice of the peace have to do with programs or new ways to do things, but if you have any effect on any of that, then what would be one thing you'd like to see implemented from a justice of the peace perspective? Something that you think that could really help.
Programming is one of those interesting things. So the court generally doesn't pay for programming. It doesn't come from the taxpayer's dime. It often partners with things. The main partners are your substance abuse people. There are other charities in town that actually do a lot of good things. There are some that specifically work with helping people get out of generational poverty. And one may think, well, why does that matter? Not everyone always has the same benefit of the same support group or friends who realize how much better life can be when you get a job, you go to work, you save your money, you budget, you do those things, and all of a sudden you see yourself in 5 years like, life's actually pretty good. I was able to save enough for a vacation. I was able to get my kids into the sports that they want. Helping people or connecting people who otherwise find themselves choosing to be surrounded by other criminal elements, breaking them out of that and changing the support group, that goes a long way. We have a lot of great mentorship charities. We have other budgeting charities. We have lots of things like that. Connecting our first-time defendants with that changes their life and keeps them out of the system, which ultimately saves the community and the taxpayer as a whole.
You have
No.
Okay. I just, the last thing I've been asking everybody is, do you have any questions for us? And is there anything we haven't covered or talked about that you think we should?
I don't have any questions for you guys. I'm incredibly grateful that you asked me to come speak with you all.
Nice.
I think you guys have asked pretty much everything. I mean, we talked mostly probably about the criminal element that goes with the justice of the peace's position. So I think things that probably weren't covered, small claims is covered by them. I think it's important for people to know that the majority of those litigants, probably 98% or so, are unrepresented. And so the great thing about small claims, having a judge who knows the law allows those people to come in and tell their stories and allows the judge to properly apply the law to those facts. In absence of the knowledge of the law, disadvantages our pro litigants who don't have the same education. So I think that's important. And the other things, one of the other big things that are covered by a justice of the peace are your protective orders. We have temporary protective orders, we have extended protective orders. You have them in all different categories, from domestic stuff to harassment to all different things in between. And again, that's where experience working in the criminal justice system goes a long way. We have had people, I've worked on cases where people level orders as part of divorce proceedings to try and get one up on the other spouse. Those come up. Seeing through that versus times when there's genuine fear, harm, risk, threat, those types of things. Because one of the things that I know is that every interaction with the justice system has an effect on someone's life. The more of them that are positive, the better. And especially when it comes to protective orders. The last thing we want is something ordered that's improper. But we want to make sure we're certainly taking care of all those people who are in need of protection.
Very good.
Thank you so much.
Thank you.
Absolutely.
Thank you.
Thank you, guys.
Thanks for coming in.
Yeah.